Why is a will or a revocable living trust not enough? You are probably familiar with the term will and revocable living trusts, but maybe less familiar with the term durable power of attorney. All of these are very important estate planning documents. The difference is that a will and a revocable living trust, when people say, oh, I need a will or I need a revocable living trust, what they likely are thinking about is what happens to my assets when I die? Where do they go? People will have a will typically because of the simplicity of a will, even though a will often mean that there must be a probate on death. But a will says who you are, who your family is, and where your assets go when you pass. A revocable living trust says something very similar, but it's far more complex in its setup. A revocable living trust is a document that you sign, and it says where your assets go when you die, but it also says what happens to your assets while you are alive. And why it's more complex is, just let me give you a simple example. If you have a revocable living trust and you own your home, you need to make sure that there is a new deed that puts your home into the name of the trustee of the trust. You could be the trustee of the trust yourself, but if it's in your individual name, it's not in the name of the trust. So it has to be in your name as trustee of your trust. So this is where it gets more complicated. Your bank accounts have to be in the name of the trust. But the idea with a revocable living trust is that on your death, the assets go where you want them to go, where you said that they should go, without having to go through a probate process. And sometimes a revocable living trust is a great planning tool. Sometimes it's a terrible planning tool, depending on whether you want to protect assets for your spouse when you're gone. In that event, at least in Washington and Idaho, a will's much better. What we've been talking about is what happens when you're gone. What if something happens to you during your lifetime such that you're unable to manage your own affairs? Well, if you have a revocable living trust, then you probably named what's called a successor trustee, and they are managing the assets that are titled in the name of the trust. But how about the assets that are outside of the trust? You probably didn't put your car in the trust. That's a big liability. You can't put your IRA, your 401k, or other assets into the trust because of tax reasons. What if you need to change, or somebody wanted to change the beneficiary designation on those assets? Nobody can. What if somebody needs to speak to your doctor? Well, your trust isn't going to help you with that. You're going to need to have durable powers of attorney for health care, for personal decisions, so that somebody can speak to your doctor. Now, most states have a hierarchy because it is not that unusual that people haven't got the right estate planning documents in place, and the doctors need to know who can I speak to. And typically the order, at least in Washington, is a guardian, a designated attorney in fact under a durable power of attorney, spouse, then children, and on and on. So, are you comfortable with leaving to some statutory hierarchy who is going to speak to your doctor for you? Recall, your revocable living trust doesn't give any authority for anybody to speak for you during your lifetime. So in order to have somebody with authority to speak for you, you need durable powers of attorney. That is why a will or a revocable living trust is not enough. And if you don't have the durable powers of attorney, the state will step in. There will be a court-appointed guardian, conservator over you and your affairs.